Hi, I'm Miriam Becker-Cohen, and I'm the Douglas T. Kendall Fellow at the Constitutional Accountability Center. Today I'm going to be talking to you about an important case called Terry versus United States, in which the Supreme Court heard oral argument this morning. The issue in the case is whether certain people who were convicted of low-level crack cocaine offenses can benefit from a provision of the 2018 First Step Act and seek reductions of their sentences. So I'm going to start by giving you a little bit of background about the case before I talk a little about the oral argument earlier today. So going back to the 1980s, at that time, Congress passed a law that created a new sentencing regime for people convicted of crimes involving drugs, including powder cocaine and crack cocaine. And for purposes of criminal punishment, this law treated every single gram of crack cocaine as the equivalent of 100 grams of powder cocaine. So crack cocaines were treated 100 times more harshly for sentencing purposes. The result of this disparity was that Black people who were more frequently charged with crack crimes were sentenced to significantly longer prison terms than white people who were more frequently charged with powder crimes. So pretty soon, the U.S. Sentencing Commission, which is an independent agency in charge of the federal sentencing guidelines and research related to them, they reported to Congress that the 100-to-1 sentencing disparity was too high, it was unjustified, it perpetuated race-based differences in the criminal justice system. And after years of reporting along those lines, finally in 2010, Congress passed the Fair Sentencing Act. And the Fair Sentencing Act reduced that 100-to-1 disparity down to 18-to-1. So there's still a disparity, but it's much smaller. However, the problem with the Fair Sentencing Act was it only applied to people sentenced after its effective date of August 3rd, 2010. So thousands of people remained in prison who were serving sentences that were imposed under the old unjust sentencing regime. And that's where the First Step Act of 2018 comes in. So Section 404 of the First Step Act makes the Fair Sentencing Act retroactive, meaning basically it permits courts that imposed a sentence prior to August 3rd, 2010 for what it calls a offense to impose a reduced sentence as if the Fair Sentencing Act had been in effect at that time. The law defines a covered offense as, and I'm going to quote here because the language is important, quote, a violation of a federal criminal statute, the statutory penalties for which were modified by Section 2 or 3 of the Fair Sentencing Act of 2010. So the question in this case, in Terry, is about how this language of the First Step Act applies to a particular criminal statute, 21 Usc Section 841. The statute covers a wide range of drug crimes, including, as relevant in this case, possession with intent to distribute crack cocaine. So basically 21 USC 841, Section 841 sets up 3 tiers of punishment. For subparagraph A, which carries a mandatory minimum, that means minimum sentence term of 10 years in prison. Before the Fair Sentencing Act, that punishment was triggered by crimes involving 50 grams of crack. The Fair Sentencing Act changed that triggering amount to 280 grams by amending the quantity of crack in the text of the statute. So they struck the 50 and replaced it with 280. For subparagraph B, which also carries a mandatory minimum, this time of 5 years, the Fair Sentencing Act changed the triggering amount of crack from 5 to 28 grams. And then for the relevant provision in this case, subparagraph C, there's no mandatory minimum, and it applies exclusively to the lowest level crack cocaine offenders. And the language of subparagraph C says that it applies, quote, except as provided in subparagraphs A and B. So subparagraph C directly references subparagraphs A and B, whose text was amended by the Fair Sentencing Act. So backing up for a minute, remember the First Step Act permits reduction of sentences if the Fair Sentencing Act, quote, modified the penalties of the statute. So the petitioner's position in this case is that subparagraph C was modified, even though its text wasn't amended, because the amendments to subparagraph B had the effect of raising subparagraph C's ceiling from 5 grams to 28 grams of crack. So let me give you an example to explain this. Before the Fair Sentencing Act, let's say you were charged with a crime involving 6 grams of crack. You're put in subparagraph B because its floor was 5 grams and you were charged with 6 grams. And so you face this 5-year mandatory minimum. But the Fair Sentencing Act raised subparagraph B's floor from 5 grams up to 28 grams. So now your 6-gram offense is in subparagraph C, not subparagraph B anymore, because by raising subparagraph B's floor, the statute modified subparagraph C by raising its ceiling. So now you're in subparagraph C with your 6-gram offense, and you face no mandatory minimum. So we at CAC, we filed an amicus brief in this case that supports the petitioner's argument. Our brief really focuses on the distinction between the terms amend and modify, and basically we argue that when Congress wrote the First Step Act, it deliberately chose the word modify to sweep in subparagraph C and allow the Fair Sentencing Act's reduction of the crack to powder cocaine disparity to apply to all people charged with crack cocaine crimes under the old unjust regime. So moving on to the argument this morning, if you listen to the argument, you probably noticed that the respondent in this case, the federal government that prosecuted Mr. Terry, the petitioner, in the courts below, actually argued on his side of the case. The federal government changed its position in this case while the case was pending after the administration change. So as a result, the court appointed an amicus to defend the judgment of the court below and permitted the petitioner and the government to argue together on the same side of the case. And as became clear and the parties acknowledged during the argument, the government and the petitioner's positions are essentially the same. So the argument itself was quite interesting. Though very few justices seemed to buy the idea that modified, as used in the First Step Act, could mean the same thing as amended, that textual issue really wasn't the focus of the argument. Instead, most of the justices focused on the practical effect of the petitioner's and government's interpretation of this statute, and quite frankly, that interpretation gave them some pause. Basically, they were concerned by the fact that raising subparagraph C's ceiling did not change the punishment for individuals who were already in subparagraph C before the Fair Sentencing Act. So for people who were sentenced for crimes involving less than 5 grams of crack cocaine in subparagraph C, raising the ceiling up to 28 grams, they always remained in the same category. So it seemed to the justices that it seemed odd to them that those people should benefit from the First Step Act because they already faced the lowest penalties, theoretically. Of course, the counter to that, as some of the justices acknowledged, is that subparagraph A offenders who are sentenced for really large amounts of crack before the Fair Sentencing Act, say 500 grams, are in the same boat. So the modification of subparagraph A from 50 grams up to 280 grams, it didn't change their category either because they were always above subparagraph A's floor. And yet there's no dispute that they get to benefit from the First Step Act. So it's not clear why Congress would want to afford relief to people sentenced for really large amounts of crack and not those sentenced in subparagraph C for really small amounts of crack. The justices expressed some concern about something called the Career Offender Guideline, which some of them viewed as exclusively driving the sentences of people like Mr. Terry, meaning the change to the drug quantities for purposes of sentencing really didn't affect their sentences in the view of those justices. Notably, Justice Gorsuch didn't ask a single question during the oral argument. So we'll definitely be curious to see how he comes out in this case, given his professed commitment to textualism. We'll be watching closely to see what the court does. So now, I know this case is really technical and a little hard to follow. So before I sign off, I just really want to break down what it's about for you. First, this case is not about automatically giving people lower sentences. Remember, it's just about who gets to petition for a reduced sentence. So judges still retain discretion to decline to reduce people's sentences based on their review of certain sentencing factors. Second, this case is not about giving people a windfall. Remember, the whole point of the Fair Sentencing Act was that Congress recognized that it had made a mistake, and it tried to fix it. And the point of the First Step Act was to make that fix complete and extend it across the board. What this case is fundamentally about is whether the court will choose to construe a relatively new statute with fidelity to its text, history, and purpose. That is, being a small but important first step, as the title says, towards eradicating racism and inequities in the criminal justice system. So to learn more about this case and to read the brief that CAC filed, please visit our website at www.theusconstitution.org. Thanks so much for joining me today.